when we began this convergence process and the creation of the model, I think there was a misperception among some that was all about reducing costs at the expense of the law firms. But what I think they found out over time, that our client, DuPont Company, and the various businesses have any number of objectives that are of vital concern to them when confronted with litigation. It could be product disparagement, harm to the reputation of the company, disruption of the business by way of litigation activities, or simply, if we're going to settle, the timing of the settlement might be critical to the business as to when it might occur during the course of a fiscal year. So these are considerations above and beyond simply the cost. The cost may be a concern, but ultimately the objective of the business might be something radically different or in complement with the cost issue. They need to have a firm understanding as to where the business or the business direction, because the litigation in many instances will invariably reinforce where that business is going. It could be intellectual property. Is this litigation going to be a facilitator of growth? Will it enable us to protect our patent estate from infringement by others? Will it be a source of revenue through licensing? These are the sorts of things that the businesses are keenly interested because they all impact its bottom line. In addition, they need to have a sense of, with respect to what this litigation might do by way of impacting the cost of doing business and the timing, as I said, of any settlement, and whether any accrual needs to be taken, and if so, when. All of these, again, affect the business's profit objective and bottom line.
There's usually not enough discussion, either within the law department or between a law department and its outside counsel, of exactly what the company's specific goals might be in a particular matter. Typically somebody will say, we need to win this case, but they may not really mean in their minds win in the sense of an outright victory over the opponent. Win may be something very different than the lawyers may think. Yet if I, as an in-house lawyer, tell my outside counsel we need to win a case, that outside counsel is going to immediately start pursuing certain tactics with that ultimate goal in mind as he or she defines it, which may be very different than how I or my business client might define it. So I think there's a great need for much more discussion about exactly what those goals are and how the lawyer's efforts can achieve those goals consistent with the business operation.
And just to add to that, in many cases we're in litigation with valued customers or suppliers or distributors. Those relationships are very important, so we need to do or conduct the litigation in a way that doesn't forever undermine or irreparably harm those relationships.
Too often the direction given is too succinct to give them that full breadth of the vision. And so, particularly, trial lawyers or litigators are very tactically oriented. So they are immediately thinking about, what motions might I file, what steps might I take in discovery, regardless of what that might do to the other side's resolve. And, when you take a really hard line in litigation, the other side will tend to get its back up, in many cases legitimately. And so Tom's right that a valued relationship could be destroyed by pursuing, a dispute to the nth degree when you didn't have to go that far. So there's a real risk there that people ought to be aware of.
So the key is communicating with the real client, the business client, and understanding exactly where they want this litigation to ultimately end up or how it can be resolved.